Suspended ANC Secretary General Ace Magashule has filed a notice of his intention to appeal a Gauteng High Court judgment that upheld his suspension. It's in a 14-page application which was signed and filed at the Supreme Court of Appeal. It said that President Cyril Ramaphosa, Deputy Secretary General Jessie Duarte and the party are the respondents in the matter. In his appeal, the embattled Secretary General argued that the High Court in Johannesburg made multiple errors when it upheld his suspension. We continue our conversation with Mpumelelo Zikalala, who's a legal analyst, as well as advocate Romeo Nthambeleni, who's a legal analyst. A very good evening once again to you, gentlemen. Thanks for staying with us. So let's start with this. So Magashule says the court got it wrong when he maintained his belief that the party's step-aside rule was unconstitutional. Advocate Nthambeleni, let's start with you. What were your thoughts on the court's findings and what prospects of success he has in appeal?
Look, thank you very much, Tsepiso, for that question. I think I've read the judgment thoroughly. It was a well-written judgment, and it was a judgment by 3 judges, that were very sound and were very clear on the principles of the law and how the law ought to be applied to members of political organization, as the person that we are speaking about, in Ace Magashule. So I believe that that judgment is tight, and to overturn it will not be easy at all. But as we know, in our legal system, that when you are not happy with the judgment, you appeal to the higher court. So let's see if a different court will indeed arrive to a different conclusion and give a different judgment from the 3 judges that have said in the Johannesburg High Court.
Mr. Zikalala, a very interesting part of the judgment which Judge Kolopin read out was that Mr. Magashule himself was very much involved in the process in relation to the development and formulation of the resolutions of the National Conference. So I'd imagine that that pretty much says that he can't now balk at them and say that they are unconstitutional simply because it applies to them. Would it, if at any stage, record his objection, if he had put any, would that have helped his case?
I don't think so, because you must remember that the way in which resolutions are then turned into rules of that form part of the ANC Constitution, it has not involved one person. Mr. Ace Magashule, as the person who is the chief administrator as described by the ANC Constitution, then presides over them, but the most importantly must ensure that they are implemented in a way which is in line with the Constitution. Now, if you look at that particular rule, or let's call it the step-aside rule, it is very specific as to who holds the power or presses the button of suspending someone. It then says it is the provincial secretary, and it's also him as the secretary general. So it would have made a bit more sense if he had attacked, or maybe used in his legal matter, an instance of saying, I want to come to this court and say to this court, yes, there's a rule that exists, is precautionary in the way in which it is being done. However, I do feel that there was non-compliance with the ANC Constitution, because the person who was meant to press the buttons was not the person that actually fired me, or let's say that's the person that suspended me. The correct procedure of following it would be going back into the ordinary way of suspending members of the ANC, making sure that I'm able to put my side of the story effectively, and only then that particular decision of my suspension could have been done. It moves on to the second realm of his stance of maybe the point in which the court could have taken into consideration of saying, yes, there's an audi ad partem rule that applies. I have a right to be heard. But in this case, I was not heard by the appropriate body. In fact, I was heard or semi-heard, and my matter was not ventilated in a forum and in the manner that is supposed to be heard. So there's again non-compliance with the ANC Constitution in that part. I think if he had stuck to that particular route, the chances of success could have been greater. But as we move to the Supreme Court of Appeals, I think he's going to, maybe he'll get a second chance of further explaining that particular part, and the court may come to a different conclusion of saying, is there a meaningful right to be heard? Was this process or was this exercise done in a manner which must be accepted by the court? If it wasn't, then he could come out victorious at the end of the day.
Advocate Nthambeleni, there was an interesting point that he made that is a suspended ANC Secretary General, that the court failed to say how all jurisdictional requirements of the step-aside rule were met. He said the court erred in failing to answer the question whether and how all of these requirements of the Rule 25.70 were met, failing which the suspension could not conceivably be lawful. What exactly does that mean?
Yeah, I think that issue of jurisdictional requirement deals with the procedural requirements that are actually set out in the rule itself. As my colleague has actually indicated there, that the way in which the case was formulated was incorrect in a manner of addressing points that were supposed to have been correctly addressed. So those jurisdictional requirements were not fulfilled within the positional constitution of the ANC. And that's where he was actually raising that challenge and think that it might actually find life at the Supreme Court of Appeal. Mm-hmm. And where I agree with my learned colleague is where he's indicating the point that that is his case and how it was formulated. And unfortunately, so you stand and fall by your case. You cannot amend it as you go. The Supreme Court of Appeal will not look into any new evidence that will need to be manufactured as we go. Because then basically, the law says you stand and fall by your papers. You cannot chop and change as you go. Then you take your case as it is, and we will see whether those jurisdictional requirements were correctly interpreted. Because what the judges in the Supreme Court of Appeal will be looking at the interpretation at whether there's a correct interpretation and the law was correctly interpreted. All so right. As far as I'm concerned, I think that is what will be looked at, but not to really look at the whole case as to what my colleague was saying was formulated in the beginning. Once you have formulated them and you brought it in an agent application form that it was, you stand and fall by your papers.
All right. It's such a pity we have run out of time, because I did want us to talk about Mr. Magashule's accusations that the court its judgment was littered with countless examples of perceived bias and contained distortions and misrepresentations. Thank you so much for speaking to us. That there was Advocate Romeo Nthambeleni, as well as speaking to us there is Mpumelelo Zikalala, both legal analysts. Thank you very much.